Can't hear you. Can you hear me?
Can you hear me now?
Yeah, can hear you now. You can hear me clearly?
Also. Yeah, I can also. Great.
Hi, Mangla. Am I audible?
Yeah. Hi, I'm Ratna.
Hi, Ratna. Sanjoy here.
Yeah, we've met once in Rinda's house.
We started 11, right?
Yes, sir.
Okay. So I'll come back.
Am I?
Just setting
Oh,
this
sure,
up.
sir.
Yeah.
Sure, sir. Sure, sir.
Mangla, Abhilasha will begin.
Sorry. Yeah, she will begin the thing. So, and after that, you take over, and then I'll start with the panel discussion. Hi, Arti. We'll be starting at 11 o'clock.
Hi, thanks, Mangla. Yes.
Can you hear me properly?
Yes,
My
I can
voice
hear you.
audible?
Yeah,
Great.
I can hear you.
Hi.
Hi, Ablasha. You were on mute. I
Yeah.
can't hear you. You might have to connect, join audio. Check the bottom right side. You'll see join audio. No, can't hear you.
Just leave and rejoin.
Can't hear you. Yeah, leave and rejoin. Or just check your settings, the audio settings.
Hi, sir. Good morning.
Good morning, sir.
We can't
Sir,
hear.
you're on mute.
Good morning. Good morning.
Abhilasha, you're on mute. Can you hear us?
Yes, I can hear you all.
Hi.
Great.
Yeah.
I'm so sorry, guys. I really don't know how to change this background, and I'm appearing as if I'm in space.
I think that's okay.
It's
I
fine.
hope that's all right. Okay. Good morning, everyone.
Just one second.
Yeah.
We'll just check if we've gone live.
Okay.
Do we need to switch off our videos?
No, the videos will be on so that
Okay.
that is.
Sure.
Oh, nice.
It's gone.
Yeah. I have tried some things given below. Let me know when to start.
Okay, we're live. So Abhilasha, please start.
Okay. Good morning, everyone. A very warm welcome to you all. We welcome you to part 3 Samvidhan series in collaboration with LiveLaw. Today, we are going to launch our very first report from the series, which is titled as The Judicial Power of Contempt, Upholding Authority or Restricting Speech. Part 3 is an organization that comprises of lawyers, researchers, social workers who are passionate about rights enshrined in Part 3 of our Constitution, which is, of course, fundamental rights. We work with survivors from disadvantaged groups and communities and the organization who support them in seeking justice or seeking accountability from our executives and administrators and the people who are sitting in power. Now, as I have mentioned already, that part 3 derives its inspiration from Indian Constitution, fundamental rights enshrined in Indian Constitution. This report is our very first attempt at trying to understand one of the very crucial fundamental right, that is freedom of speech and expression, injected through Article 19 in our Constitution in the context of contempt of courts Act, which again emerges from the very article itself in the form of reasonable restrictions. Now, this report I'm talking about is, guys, available on our website for the moment. You can access it on www.part-3.org. And of course, we'll soon be releasing it on other media platforms as well. But for now, you may access it on our website. Moving ahead. Since last few years, the overuse of the Contempt of Court Act by the judiciary, as well as by few others, have for putting restraints on simple acts of expressing opinions or raising certain concerns, citizenry concerns, has made us question the act and must have given rise to several questions in your head. These questions might be like when the act and law originated, evolution of the act, or is it still relevant in today's day and age? or is it a relic of past? Or maybe do we need to amend the act to suit present time and age? Or other question that might have hit some of us is also that, is it being used against certain individuals who are raising certain specific questions? So all of these questions will be answered today in our panel discussion with our very interesting and renowned guests who will be, of course, sharing their life experiences and some anecdotes vis-a-vis the Contempt of Courts Act. We have with us Mr. Prashant Bhushan. Mr. Bhushan is a renowned lawyer and a civil liberty champion who is there in legal fraternity for 3 decades now as a public interest litigator. And Mr. Bhushan has himself recently faced contempt charges and has challenged the law, the Contempt of Courts Act, in the court as well. And all of us must remember that Mr. Bhushan had to pay ₹1 as a cost for his freedom of speech and expression in the highest court of the land. We welcome you, sir. Then we have Mr. Sanjoy Ghose. Mr. Ghose is a designated senior advocate, and now he's also a published author of the book, How Gaurango Lost His O. Mr. Ghose is an outspoken loyalist to our judiciary and the bar, and he has never restrained himself from putting his opinion on several public media platforms, even though being in an unfavorable environment. And of course, we all know that Mr. Ghose is also legal fraternity's Twitter hero. We welcome you. We warmly welcome you, sir. Then we have Ms. Arti Raghavan. Hello, ma'am. Ms. Raghavan is an advocate in Bombay High Court in Maharashtra, and she is representing Kunal Kamra, again, a very vocal voice, in the Supreme Court of India, in the criminal contempt proceedings initiated against him. We are very eager to hear from you, ma'am, and we warmly welcome you to the event. And now, before moving ahead to the panel discussion, I'm sure everybody is eager to hear our guests. I would, of course, and we are going to conduct it in a very interesting manner. But before moving ahead, I would request Ratna to present a brief of the report to our audience. Ratna, if you may please go ahead with the introduction of the report.
I'll do that. Thank you, Abhilasha, and thank the panelists for joining us today. So our colleague Harsh isn't here today, so he's written the report. So I'm just going to give you all an overview of the report. So I also want to just go back to the conversations we had while we conceptualized the report. So all of us in the past couple of years, like Abhilasha had mentioned, we are seeing a use of contempt powers. I don't know whether it's being used more or less, but we're seeing a certain kind of use of contempt powers, like she said, to restrict certain forms of speech and against certain kinds of people. So what we wanted to do was to examine the law and the jurisprudence on criminal contempt to make sense of the ways in which it is used to restrict free speech, the ways in which it is used to shield almost against efforts to hold the judiciary accountable, whether for corruption or bias. So to begin with, we've looked at contempt powers on the whole. So civil contempt is essentially action against the deliberate or willful disobedience of court orders. And this is an important power. It's clearly defined, and courts are almost reluctant to use this power, especially against when the state is a respondent. So we have not looked at civil contempt. We've actually only looked at criminal contempt, and particularly the ways in which it affects freedom of speech and expression. So again, within criminal contempt, the report has identified certain forms of acts which, so it's identified 2 aspects, certain acts which actually affect the administration of justice. For example, influencing witnesses or threatening or misbehaving with judges, which often happen in trial courts. And another category, which is acts which are essentially speech and expression, which offend or scandalize the court, right? So the former category, acts that actually tangibly affect the administration of justice, the report has actually flagged how the IPC itself deals with a lot of these acts. Chapter 10 and 11 of the IPC defines acts that are contempt of lawful public authority, It has offenses of false evidence and offenses against public justice. So while we haven't gone into this, this is actually a very interesting aspect of criminal contempt, where it would be very interesting to see whether these offenses are actually used as much as the more generic power of contempt of court. So to go back to the report, we've looked at how it affects freedom of speech and expression, essentially. So part A of the report looks at the law on criminal contempt within the framework of the constitutional right to freedom of speech and expression and reasonable restrictions. The report was in fact forced to look not so much at whether the power itself is a reasonable restriction, but actually whether its application and the ways in which it was used and the circumstances in which it was used constitute a reasonable or qualify for as a reasonable restriction. Part B of the report went on to examining the jurisprudence and case law in much more detail. So here the effort was to really dismantle the definition of contempt. So contempt is defined, there are all these phrases that are used in the statutory definition, things like scandalizing or tends to scandalize a court, lowers or the authority or tends to lower the authority, prejudices the due course of any judicial proceeding, interferes with or tends to interfere with the course of any judicial proceeding, interferes with or tends to interfere with the administration of justice. So now what do these phrases mean? Are they, what have judgments said about them? After all these years, are we able to say scandalizing the court means this? Lowering the authority of the court means this. And so in effect, do we, after all these years, do we know what not to do and how not to be contemptuous? Do we get that from judgments? And so the other thing that the jurisprudence, by looking at case law, we've tried to flag certain themes that come out and which have actually been discussed a lot, but these are actually themes that we see repeated in almost every judgment. One, of course, is the conflict of interest, whether the judge hearing the contempt proceedings performs the role of a prosecutor as well as a judge. Another very important issue is how almost each and every judgment on contempt powers says that contempt power should be used sparingly and with care and caution. However, we don't know what this actually means because the judgment then goes on to do, it goes on to convict for relatively minor things. So what does use of contempt power sparingly mean? What are the circumstances in which it should be used? That is not very clear, and I hope the panelists will be able to shed some light on that. Another issue is, of course, the jurisprudence reinforces the statute in being textually vague and overbroad. The jurisprudence shows the arbitrary enforcement of contempt law by the judiciary. We've also looked at how contempt itself restricts speech more than other speech-related crimes. And to do this, we've looked at the constitutional framework on reasonable restrictions on freedom of speech and expression. And as we've also looked at the consequences of contempt powers, where the consequences are that now there is almost a risk inherent in demanding judicial accountability. And obviously there's a chilling effect both on freedom of speech and expression and on demanding judicial accountability. So essentially, like I said, the jurisprudence reinforces the statute in being vague, arbitrary, uncertain, inconsistent, and overbroad. Another section of this report looks at the procedure, and this is something that has been very interesting for all of us because it explains how how contempt proceedings are initiated, which are essentially by a court on its own motion or on a complaint made by the Attorney General or the Solicitor General of the Supreme Court or the Advocate General in case of a High Court, or on the complaint of a private individual with the written consent of the law officer, of the Attorney General or the Solicitor General. So here, this actually laying down the procedure exposes in some sense the extent of executive power and hence executive discretion in even allowing contempt proceedings to be initiated. So this again begs the question of whether it's only the judiciary that's being protected through by the existence of contempt powers. So the findings of the report are essentially that the manner in which contempt powers are used could lead people to feel that contempt powers are being used to stop people from asking questions of the judiciary, from holding it accountable. Another aspect that's been flagged as in the findings is that whether the term scandalizing the court should be removed. And I think there's a petition pending in the Karnataka High Court on this issue. And lastly, how do we reduce the vagueness? How do we ensure certainty? And how do we ensure uniformity of application? So with that, I'm done. This is like a very brief overview of the report, but I'll hand it over to Mangala now to moderate.
Thank you, Ratna, for that summary. And I think you've really set the context for our discussion today. I'd like to welcome our panelists. Thank you for taking out time and being with us here today. And also our viewers who would be watching us live on LiveLaw's platform. So to begin with, I'd like to ask Mr. Prashant Bhushan, sir, as someone who has faced both sides, you faced contempt charges under the Act, and also you've challenged the constitutional validity of the Act. So, sir, what has been your experience of engaging with the law, and what is it that after this journey that you now think of criminal contempt as a concept in our law?
Thank you, Mangala. First, of course, I want to congratulate Part 3 Action Research and Resource Center and all of you for doing this absolutely brilliant exercise. I'm really heartened to see that so much effort has been put into dealing with this whole issue of contempt and freedom of speech, and it is done so comprehensively. So hats off and congratulations to all of you. It's certainly a very, very important issue. As you know, I have also been subjected to contempt proceedings, and I have also challenged the constitutional validity of one part of the Contempt of Courts Act, which deals with scandalizing the court and lowering the authority of the court. So let me first tell you that there are broadly two aspects of contempt, as we all know: civil contempt, which is disobedience of the orders of a court, and criminal contempt. Now, criminal contempt, civil contempt, there is no problem in my view. Of course, the disobedience of the orders of the court should be punishable and should be actionable, because how else do you enforce the orders of the court apart from execution? But sometimes execution is not so easy, because, for example, take the case of what is happening currently, that is the judgment of the Supreme Court regarding judicial appointments is not being followed by the executive. That is, the collegium's recommendations are either not being acted upon, the executive or the government sits upon them, and even when they send them back and the collegium unanimously reiterates them, even then the notifications are not being issued. Now, how do you deal with this problem? So, there are two ways of dealing with this problem. One is to say, well, once the collegium has reiterated it, no notification is required and the judge will automatically be sworn in. The other way is to issue a mandamus and thereafter proceed against the law minister or whoever, law secretary or law minister, for contempt. And then by the penal power of contempt, force his hand. So I don't think there is much problem with civil contempt. The problem is with one part of criminal contempt. Criminal contempt is also in two parts. One is interfering with the administration of justice. Now, of course, if somebody doesn't allow the court to function, which has often happened, for example, if the lawyers go on strike and they do not allow the courts to function, don't allow the litigants to enter, don't allow the judges to proceed, that, in my view, is interference with the administration of justice. That's what the Supreme Court has also held. And that's criminal contempt, which is actionable. I don't think there is any problem with that either. Similarly, There can be other ways in which you can interfere with the administration of justice. The other is, for example, if you threaten a judge, that look, if you decide against me, I'll break your leg or I'll shoot you. If you threaten a witness, if you threaten a lawyer of the other side, that's interference with the administration of justice. That's criminal contempt, and that should be actionable. There is no problem with that either. The problem is with the second part of criminal contempt, which is scandalizing the court or lowering the authority of the court. Now, this part was brought in on the basis, you see, the origin of this is that the courts in England were considered to be representatives of the crown or the king or the queen, and therefore any allegation made against the courts was regarded as an allegation against the king or queen, and therefore it was made into an offense under the of contempt of court. Thereafter, after the king and queen went away and democracy was established, the residual justification of that was that it is essential for the administration of justice to preserve public confidence in the courts. And somebody who makes allegations against the court or thereby lowers the authority of the court is interfering indirectly with the administration of justice, because he is leading to a loss of public confidence in the courts. That was the justification on which this law was continued for many years thereafter.
Sir, I think we have lost you.
Seeing the confidence in the judiciary or in judges does not rest upon what any member of the public may say or not say about the judiciary. He said that that confidence has to rest on much surer foundations. And those surer foundations have to be how the actions and judgments of the judiciary and the judges are in general viewed by the people or not.
Right.
Unless the actions and judgments of the judiciary instill public confidence in the judiciary, see, if they do instill public confidence, the remarks of any one individual, if any disgruntled litigant makes some allegation against any judge or the courts, it is dismissed by the people as the act of as the flailing of a disgruntled litigant. It is not taken seriously. So therefore, public confidence in the judiciary does not depend upon what an individual may say or not say. If somebody is saying something which is unjustified, by and large, people see that this is totally unjustified. This is just the rant of a disgruntled litigant. If somebody is saying something which is justified, then yes, it should lower public confidence in the judiciary. If somebody is saying that, look, the court has done this, and people see that as a very justified criticism of the court, then it should lead to lowering public confidence in the judiciary, because that is how improvements in the judiciary will take place. It is only when the people are able to make free comments without being fearful of being hauled up for contempt that the problems with the judiciary will come out, that the problems with individual judgments or judges will come out. And therefore, and you see, there is, if somebody makes a scurrilous allegations, today some of the judgments have said that criticism of the court or a judge is all right. That's not scandalizing the court or lowering the authority of the court, but making an allegation of corruption, etc., that amounts to scandalizing. Now, the point is that sometimes the allegation of corruption also is correct. For example, I had not named those judges. One of the cases of contempt against me was where I had said that in my view, almost half of the last 16, 17 Chief Justices were corrupt. Now, that's my perception. That's my honest perception. I did not name those judges. But the point is that even if somebody feels that this is wrong, the thing is that the ability of the court to function or even the public confidence in the court will not rest on what I say, even if what I say is wrong. It will, as Lord Denning said, it must rest on surer foundations. So therefore, and if that is the case, of course, thereafter my father intervened in that case and he gave in a sealed envelope the names of 8 out of those 16 judges who he said were corrupt, and he named 6 who he said were honest and 2 who he said were question mark. Now, unfortunately, that 50% ratio seems to have continued even after that. That remark was made more than 10 years ago, more than 12, 13 years ago, but that ratio seems to have continued. So the problem lies with this part of, because this has been used. I mean, take the second case of contempt against me. What had I said? I had said that this Chief Justice, then Chief Justice, there were 2 tweets on which they had issued those suo motu proceedings against me. One of them was that this Chief Justice of India at that time, Chief Justice Bobde, he is sitting on a 50 crore motorcycle without a mask, and he has shut down the Supreme Court virtually. He had locked down the Supreme Court during that lockdown. Virtually no work was happening in the Supreme Court. So that was one of my tweets. The other tweet was, what was the second tweet? There was one other tweet for which they had proceeded against me. That was that when the history of this collapse of democracy is written in future, the historians will note the role played by the Supreme Court and in particular the last 4 Chief Justices in the collapse of democracy. Because I felt that the last 4 Chief Justices, the then Chief Justice included and 3 who preceded him, had played a major role in allowing the executive to run riot over our democracy and fundamental rights. They had not stopped, they had not done their job or their duty to protect fundamental rights or to protect democracy. So for that also contempt proceedings were initiated. Now, one problem with these contempt proceedings is that sometimes the judge against whom the remarks are made, he himself sits in judgment. And sometimes, in this case, the Chief Justice, he nominated the bench to deal with this contempt against me, even though that judge was retiring, Justice Arun Mishra. He was the go-to man for several Chief Justices. He was the go-to man for Kher in the Birla Sahara case. He was the go-to man for Deepak Mishra in that medical college scam case. He was the go-to man for even Gogoi in the sexual harassment case, where he held an extraordinary sitting on Saturday and had Arun Mishra on his bench. And he was the go-to man for Chief Justice Bobde also in this contempt matter. He set up this bench headed by Arun Mishra. And of course, they held these hearings and ultimately decided that this was the grossest possible contempt, but ultimately they ordered a 1 rupee fine, etc. So therefore, that's why I have always said that this part of the contempt law, scandalizing the court and lowering the authority of the court, and that is why Mr. N. Ram, Mr. Arun Shori, I and Mr. Prashant, former editor of Outlook, have jointly challenged this part of the contempt of court law, because all of us have at some point or the other faced contempt proceedings on this ground. So I'll stop here. Thank you.
Thank you, sir. Sir, on that note, and specifically what you said about the inherent conflict of interest, I'd like to bring in Mr. Sanjoy Ghose. Sir, if you could sort of see, I mean, one of the opinions or perceptions that we have heard from people, and which
Your voice
is,
is cut.
am I audible?
It's fine. Go ahead. Go ahead. I
Okay.
think
So one of the perceptions is that the judiciary operates behind closed doors.
Yeah, just
And
about
so,
it has gone. Yeah. Go ahead. Go ahead.
And the fear that litigants might have that there could be even though if a different
You
judge
are audible now.
Yes, that even if a different judge is listening to the proceedings, that there is a close association that judges have, both personal and professional. So on that aspect, what would you? I mean, the main. How does the law reflect on the credibility of the judiciary when they're sitting as judges in their own cause? And and this is a law that actually aims to protect the judiciary's dignity in that sense. So, Mr. Sanjoy Ghose, sir, what would you? I mean, how would you perceive this issue that we have with the contempt law?
Thank you, Mangla, for having me. Am I audible?
Yes, sir.
Okay. You've actually flagged the most important issue, and that is credibility. Because at the end of the day, what are we talking about? Why is this contempt law there? It is to protect the credibility of the judiciary. Now, before I speak about that, I must add a word of compliment. I did write the foreword, but let me be honest, I did not read your report that thoroughly when I wrote the foreword, but I did read the report thereafter. So as they say, post facto, natural justice was followed. And it is brilliant forget everything else. It is brilliant because of the simplicity of the language. And that is very important to demystify and simplify communication. Because, we get so caught up in our ad hoc and qua and, all these legal terms that we forget that language has to, reach the consumer of justice who will not understand these complicated words and complicated terms. So congratulations to all of you who were behind the
Thank
report.
you, sir.
I love the anecdotes, including the Bahamas anecdote, which I will refer to in if you give me the opportunity thereafter. Now, coming to the credibility, as you said, that, the judge hearing credibility. Now, I would like your viewers to conjure up two images. One is, of course, the day the people in the US got to know about RBG's death. That is Ruth Bader Ginsburg, the judge of the United States Supreme Court, who was so iconic because of her famous dissents and for her indefatigable energy. The day she died, there was no, no lorries and trucks bringing people with the 500 rupees and a free lungi and banana. It's a spontaneous gathering of people with candlelights, with pictures, with flowers, and it was like a spontaneous tribute. Now, cut to the second image, which I want you to think of from the same court, the SCOTUS, is the day the Supreme Court overruled Roe v. Wade, the abortion case, when the Supreme Court said that Roe v. Wade was wrong. The women do not have a right of bodily integrity and privacy in abortion. You had the entire nation, there were demonstrations in front of the Supreme Court. You had all the midnight comedy shows ripping apart the judges of the Supreme Court. And you had the social media and the journals just staring down the people. In fact, some people say in retrospect that verdict was instrumental in the Democrats being able to save an absolute washout in the midterm elections to the Congress and the House of Representatives and the Senate. So, why I'm saying this is to emphasize that the credibility does not come to a court by sending a person to jail or getting 1 rupee from Mr. Prashant Bhushan. The credibility comes from the way you deliver justice and the way you show courage in being impartial, in being compassionate, and in being fair. Now, of course, some of your viewers may say that, ye liberal wale aage, Ruth Ginsburg or abortion ka example he cited. Let me then give this from the same court when William Rehnquist died, who was a conservative Reagan appointee. And there was also such some spontaneous show of sympathy, of empathy and grief. So, we are talking about stalwarts. It doesn't matter what ideological character you have. People can see justice being delivered. And that's truly when you say that justice must not only be done, but seen to be done. So coming back to credibility, yes, it is true that in contempt matters, you have the judge deciding this. And it is, and often when it's credibility, it is subjective because, right? So, for example, as the name, I am no fan of Justice Bobde, but I must correct with greatest respect, Mr. Bhushan. Arun Mishra was requisitioned not by Bobde for his case. In fact, Justice Bobde recused and Justice Ramana then appointed Arun Mishra to head that bench. But be that as it may, I completely concur with him that he was the go-to man. Now, so we know that, for example, if Mr. Bhushan's case went to Arun Mishra, what would be the result? And let's say it went to Justice Dhulia or Justice Bhatt or some other judge of today, how contempt would be viewed. So it is very subjective. And of course, Arun Mishra has Justice Arun Mishra now has very worthy successors in the court also. So, and the same concept of what was happening, some may say is also happening right now. So not only is this one of the principal criticisms of the law of contempt, that it is actually very, very judge-centric because it goes to the root of the personality of the judge. It also goes, and how beautifully you brought it out in your report, it also goes to the personality of the litigant. I mean, let's be very clear, Mr. Bhushan is one of the most courageous lawyers I know. But let's also not forget that Mr. Bhushan has a stature. Mr. Bhushan also has pedigree. Now, that stature, and I'm saying the stature is absolutely earned on his own. Let's not take away from the pedigree, but he has both. Now, Mr. Bhushan getting 1 rupee should not embolden others to think, "Main bhi kar sakta hu," because again, that person may not face the same 1 rupee result. So let's be very clear. I don't mince words, so I'm being very honest about it. So it is also that Duda and Shiv Shankar case where P. Shiv Shankar, as you brought out in a report, who's a law minister, can get away by saying that the Supreme Court is a den of FERA violators and black marketeers, and he can get away with it. Or let's say, of course, he didn't get away with it, but EMS Namboodiripad got a sentence, though it was mild. So often contempt also depends on the person before the court, which again makes it so subjective. There is no uniform kind of sentencing policy. There's no uniform kind of markers or parameters either for the judge or for the so-called perpetrator or so-called accused person. So therefore it all adds to the vagueness. And I just want to just give 2 or 3 examples which I've quoted in my foreword to your beautiful report. And that is the story of Peter Wright, which I've talked about. Now you have Dulat and all these people in India who were spies, who were writing books post-retirement. So, Peter Wright wrote a tell-all. He was in the MI5, the British Secret Service. And it was called the Spy Catcher case. And the British government wanted a pre-publication injunction saying that national secrets would be revealed. And the House of Lords, by a 3-2 majority, actually gave the British government a pre-publication injunction. Now, what happened the next morning? The next morning, the Daily Mirror carried the picture of the 3 majority judges. But the picture was inverted, ulta.
Yes.
And the big screaming title was, "You fools."
Yes.
And then you had this contempt petition, and now you have all these law students during the pandemic. All they would do is file contempt petitions and petitioning the Attorney General for India to give consent to file contempt. The poor AG with all his advancing age had to deal with all these frivolous petitions on a daily basis. When some law student would think that the best way of getting publicity is to just file a contempt permission to initiate contempt. So when contempt was sought to be initiated, this is what Lord Templeman, who was one of the judges of that bench, said. He said, however much I may be passionate about what I feel about myself, but I can't prevent someone from thinking that I'm a fool. So how it is this perception? So I cannot initiate contempt. Similarly, the story goes, Prashant Bhushan ji talked about Lord Denning. He was another great man. And there is a story where Justice Krishna Iyer talks about, Denning may not have directly talked about it, is Lord Shawcross called Denning, he's an ass. He's an ass. And all these tattletales went up to Denning and said, take contempt action against this fellow. And what Denning says is that it is his opinion and it is wrong for me to initiate contempt. But let me try to dispel his notion by working hard, and through my judgments, let me get his confidence back. So that is how you have to deal with the issue of contempt. It has become archaic completely. In the West, contempt is hardly used. All of you, I was a little apprehensive whether you would be happy with such a scholarly work of your report, starting with my foreword, which actually talked about Hollywood and My Cousin Vinny, where you had that Judge Haller sending that lawyer Vinny every time into contempt court, into the locker on contempt of court. Once even for coming dressed in colorful clothes. But that was Hollywood, right? It's like the Bollywood version of Tariq. Courts are very different from what happens, because US Supreme Court clearly said that, the judges have to have in Craig versus Harney, and may I read that? I've quoted it in your foreword. The US Supreme Court said, the law of contempt is not made for the protection of judges who may be sensitive to the winds of public opinion. Judges are supposed to be men of fortitude, able to thrive in a hardy climate. Now, I will wind up my comments by just saying one thing. But let's also flag this. Judges are also human. And, it's really sad. And I'm told that Chief Justice Ramana even flagged this with the law minister, and I've written publicly about it also. Just because we say that the court can deal with it, the majesty of the court is in the hands of the judges. But let's also be conscious, and I have no answers. I want your viewers to actually think about this. I have no answers, but today we live in a brutal social media world where there is little responsibility for making allegations. Often you have social media handles which are anonymous. You never know who's saying what. And the kind of language that is used against courts and judgments. We had, and we saw that happening when you had that lady who was being prosecuted for blasphemy or something, and one of the judges refused to give her interim protection of the Supreme Court. And then you had the most vile form and vicious form of trolling of judges. And, then the judges, of course, there was a petition of review and the judges changed their mind. I really don't know how much this social media, trolling impacted upon the judges. The judges say we ignore the social media comments, but let's take that with a pinch of salt. They are also humans. So, somewhere we have to really think of where we are going as a society. And of course, that's a general, larger debate. But, just signing off on this, and then thank you for having me. My comments will be that it is time that we revisit this law. It is archaic, like many laws that you have, laws on marriage, laws on sexuality, laws on sedition. The law of contempt also now is requiring urgent review, and you cannot enforce respect for the law by the opacity that you show, by the kind of different double standards that you show in dispensing justice. You cannot have respect for court by force. In fact, as you all know, that one rupee sentence on Prashant Bhushan ji, or the 1 day sentencing of Arundhati Roy did not cover up the court in glory. In fact, it exposed it to a lot of ridicule during the pandemic. Instead of helping the migrant workers, instead of helping the people who were gasping for oxygen, the court was wasting precious time going after Bhushan. And all that for a tweet which was, which in someone's opinion could be obnoxious, but everyone has a right to his own obnoxious behavior. And as Prashant Bhushan ji has said, that if the concerned judge felt it was libellous, the civil remedy is available. The judge only had to invoke the civil remedy to find out what a screwed up legal system we have, because then he would be fighting that case for 25 years. Remember this also, contempt and defamation go hand in hand. Maybe time has now come to reform our law of defamation, to make our law of defamation more effective, so that there is that kind of check on this reckless tendency to get at judges and judgments. Thank you so much.
Thank you, sir. I'd like to bring Arti in quickly. We're aware that Prashant sir has to leave us at 12, so I'd like to go back to him after this.
Sure.
But Arti, quickly, just asking you, from what Sanjay sir was saying right now, my question is, in today's age of social media, and from your experience and the cases that you're dealing with under contempt law, so in today's age of social media, should judges be at all concerned about, public opinion, which is being talked about, on Twitter, on Facebook, etc. And, given the whole vagueness in the text and the arbitrary, application of the law, do you think that, let's say, if we bring in more textual clarity into the law, do you think, because the main problem is that people are not able to understand what constitutes contempt and what does not. So even if, let's say, we bring in textual clarity, do you think that will overcome the inherent doubts of fairness or free speech restrictions that we see in the law currently? So first part, of course, being that, social media, should it really affect? And I'd like to ask the same question also to Prashant sir, after you've given a response, that, is it something that is important?
Okay, so before I start, I want to again join Mr. Ghosh and Mr. Bhushan in congratulating part 3 on a fantastic report. It is extremely accessible. It's so relevant for the times. And really, it was a pleasure reading it. And thank you for having me on this panel. But to quickly get to your questions so that Mr. Bhushan can also pitch in here. On social media, well, I think that there's a lack of understanding and analysis of the nature of social media and the virality of content and the attention economy. So while, yes, there are extremely problematic and irresponsible statements, often under the cloak of anonymity, made on social media, there is also discernment on the part of the public consuming this. There is also the platform to counter this narrative that is afforded to everybody who is a stakeholder in this institution. And that is what you see happen. So if there are reckless allegations, equally, there are members of the bar, there are members of the media, and citizens who can weigh in and disabuse members of social media of any notions, of any ill-conceived notions about the functioning of the judiciary. So merely the fact that there is one problematic Instagram post or tweet, it can't be seen in isolation, and there must be an understanding of how the attention economy works in social media and the credibility that is assigned to individual users and the information or views that they put out. And I feel like, the judiciary needs to grapple with this. They've often expressed their concern about social media, but this needs to be taken into account as well. And the other element that also needs to be acknowledged is that contempt jurisprudence comes with the notion that judges are often confined to speaking through their judgments alone, and that they don't have an opportunity to really address public criticism. And well, that isn't strictly true today, because you do see a lot of judges in constitutional courts having access to rather prominent public platforms. Their speeches are widely reported. In their speeches and through their public engagements, they are able to address and engage with and possibly even counter the criticism that you see both on social media and in other forms of media, criticism of the judiciary. So the antiquated notion that, judges must be confined to only their judicial acts and their written judgments is not strictly correct. And while weighing the scales and deciding on, on when contempt law should be used and the harm that is caused to the judiciary and judges, it must be acknowledged that there is a change as far as this trend goes. So yeah, that's my 2 bits on social media. And on, clarity or statutory, clarity in terms of the definition of criminal contempt, I'm not sure whether the, the arbitrariness in the law comes merely from the lack of precision in the definition in the statute. It is, it's more the vagaries in its enforcement. Of course, scandalizing the judiciary or lowering the authority of courts are vague terms. But you must remember that the power to punish for contempt comes from constitutional courts being courts of record under the Constitution. Now, the power, why must a court of record have such a power? What is the scope of the power of contempt that courts of record wield? These are vague as far as the Constitution goes. So it's not just in the Contempts of Court Act that the vagueness comes from. It's very much embedded in the constitutional structure. And I think that, there needs to be some examination of why this power to punish for criminal contempt must be an incidence of being a court of record. A court of record, as your report also notes, is merely one in which the records are memorialized. You can't dispute the authenticity of it. One can't even say that's true of our constitutional courts. We do not have accurate transcriptions of what happens in court. That is hugely problematic. I can understand if that were the case, if there was a faithful transcription of what happened in court, then criminal contempt proceedings for contumacious acts in the face of the court, while in court and there is an accurate record of what actually transpired, perhaps makes sense. But in my limited reading of criminal contempt jurisprudence, I haven't quite established why otherwise a court of record, as is defined in the Constitution of India, requires a power like criminal contempt as it has come to be exercised now. So that's certainly worth examining while looking at the definition of the law and its vagueness.
Absolutely. Thank you, Arti, for that. And you've made a very important point of the changing times now, that the judiciary is not so confined behind their judgments. They have these opportunities of going out and talking and giving out their opinions on public platforms. Sir, Prashant sir, I'd like to ask you, and since you would be leaving us in 10 minutes. One is, sir, again, ask the same question that I posed to Arti. What do you think of, this new trend of social media, and how do we sort of, like Sanjoy sir was also saying, how do we understand that problem and deal with that problem, or what should be our idea of it? And also, sir, your last words on, what should be the way forward? In a modern democratic society, do we really need a law like criminal contempt, considering, other jurisdictions have really limited its scope? So what is the way forward that you think that this law should, the course that we should take going forward from here?
Yeah, so social media in general is a relatively more democratic medium than the mainstream media. So therefore, it's easier to puncture bogus criticism or totally unfair criticism or reckless allegations made against people on the social media than it is through the mainstream media. Because today what we are seeing is that the mainstream media, unfortunately, is now called Godi media, and it's now become an instrument in the hands of the government to spread hatred, to spread even falsehood. Now, it's true that social media is also used to spread a lot of falsehood, and also a lot of reckless allegations are made against individuals, including occasionally against judges also. But in my view, it's relatively easier for those reckless or false allegations or even falsehood, general falsehood or hatred, etc., to be countered on the social media than it is to counter it in the mainstream media, which is in the hands of a few people. Social media is relatively more diverse, more widespread, and therefore more democratic. I, however, do not subscribe to the view which some people have that we should, in a way, do away with, say, 153A, because unfortunately 153A is being often used by the police to target people who have not said anything which is hateful or which is divisive or which seeks to spread hatred against religious communities, etc. Same way, I feel that the law of defamation should be there. Of course, criminal defamation is debatable as to whether criminal defamation should be there, but civil defamation, and I agree with Sanjoy that the whole system needs to be beefed up to deal with at least civil defamation quickly. It should be able to deal with it quickly and credibly. But however, a word of caution here. You see, sometimes even civil defamation can be made into an instrument to victimize or penalize somebody who may be saying something right. Take, for example, Hindenburg, the allegations against Adani. Now, there would be, I know that there would be many judges in this country today, given the kind of climate that we have in this country today, who would be very quick and happy to label Hindenburg's allegations as defamatory. I mean, if Hindenburg was in India, to label them as defamatory and issue an order with thousands of crores against this Hindenburg. So, defamation should also only be used when it is absolutely clear defamation, where there is no doubt virtually, I mean, it should almost be on par. Even civil defamation should be on par with a criminal charge. That is, it has to be proved beyond reasonable doubt. But yes, it is true that there are a number of very, very reckless and scurrilous allegations being made on the social media against people, including judges. But I agree with Arti that judges are able to speak, firstly, themselves also on various public platforms. And secondly, there are their colleagues or other people who are able to speak on their behalf. So they can certainly, it's not true that they cannot counter any reckless or false allegations made against them. They are countered. So therefore, I don't feel that that should be a ground for retaining the scandalizing the court and lowering the authority of the court. That's a totally unnecessary and antiquated part of our criminal. However, of course, the other part of criminal defamation, which is obstructing the court proceedings or interfering with the administration of justice, that should remain. And that's not merely confined to contempt in the face of the court. It may not be in the face of the court. For example, if you threaten a witness, that is clearly interference with the administration of justice. That should be actionable. It's only this part which should be removed, scandalizing and lowering the authority of the court. So thank you, Mangala. I'll have to leave now.
Yes, sir.
Thank you for firstly writing this report and organizing this discussion around the report. Thank you.
Thank you, sir. It was our pleasure to have you here and to listen from you, your experiences and the way forward that you suggest for us. Thank you so much, sir.
Thank you. All the best.
Thank you, sir. Taking the conversation forward, Sanjoy sir, I'd like to ask you and sort of, talk about another aspect, which is this whole, the defense of truth, which is now, we have inbuilt into the law after the amendment, etc. But my question here is that, when somebody makes an allegation, let's say, of corruption against a judge, the person is really starting out with very limited information or sort of unverified information to begin with, which, perhaps which would need more investigation. There is also, and so, it's difficult for a person to actually at times plead the defense of truth because you might not have enough evidence of wrongdoing. So in such situations, or like, let's say what we saw in Mr. Bhushan's case, where he did plead the defense of, of truth, but the court rejected his argument, and without sort of analyzing or going into the detail of why his tweet was not in public interest or not bona fide, the argument was rejected. So in both of these scenarios where, it's difficult to prove defense, how does one really ask for accountability or seek accountability? And especially when we're talking about things which are very relevant in today's judiciary, of bias, of corruption, of impropriety of different kinds that we're seeing. So in such a situation, how do we balance the two things?
See, what you ask it's a big ask.
I think it's the major issue that we're dealing in, and I guess it needs more conversation.
Correct. So, what do you do when the birth of a system, it is like, even, I've always done this comparison that you have the curial system of Rome, where the Pope is elected in the Sistine Chapel behind closed doors. The cardinals are put in over there, they seal it, and only the black and the white smoke comes, and you know who's the next Pope. And of course, the Pope is not accountable to anyone except God and St. Peter. So when you start off a system where you start off with this kind of opacity, you start off with this kind of appointment, where will the accountability come? Where no one knows why certain people are appointed as judges, no one knows why certain people are not appointed as judges. You come up with so-called model, rules or code of procedure or whatever, memorandum of procedure, and then you set certain parameters of age. 45 to 55 is zone of consideration, but someone's brother can become a judge at 43, someone's sister can become a judge at 62, so 61. So, where is the accountability? And so therefore, once you are starting off this, accountability and independence are very related. And the other day, and the seminar was covered very live by LiveLaw of Aditya Sondhi, who I'm very proud to say was my junior in National Law School, Bangalore, who said that, I'm going a little astray from the topic, but this is very relevant because both are related. He said that, the independent judiciary comes from the independent bar, because a bar, as they say, is the mother of the bench. Right. And he said that if you are going to not allow independent lawyers to become judges, and you're going to hold their independence against them. Today, one lawyer has tweeted something on social media or forwarded some article which is critical of the executive, and now you've held on to his appointment, held back his appointment despite a reiteration by the court. The executive has gone ahead and disobeyed the collegium and appointed judges who were recommended much after that gentleman, and they're continuing to do so, and the court is silent. So at the end of the day, if you are not going to have independence, if you're going to continue with this model of dealing in secrecy, of trying to come to adjustments, accommodations, where will you have any kind of accountability and any kind of transparency in the way once this is done? And that's where contempt comes, that's where defense comes, that's where judicial corruption comes. So, so therefore, okay, let's be very clear that, just to, again, as I said, I sadly have no answers, but I'm laying it out on the table for all of you to mull over. Let's be very, very clear that Mr. Bhushan, as I said, is a very, very courageous person. But however, let's also be very clear that what he did was he just verbalized and made formal what people gossip in the court corridors every day.
All the time.
But none of us have the ability to actually get the information, the facts beyond reasonable doubt, which form the basis of proof, which is the basis of your defense of truth. So even at the end of the day, what did Mr. Bhushan or the senior Bhushan, the late senior Bhushan do? In a seal cover, he just gave the names, but he did not have proof. If he actually tried to do justification by truth, that justification, that defense would fail. So,
Exactly.
I sadly have no answers. I sadly have no answers. I can only say that we are, this is a mess. The judicial system is repeatedly throwing alarms. It's ringing alarm after alarm. But sadly, what it is like normal business, the people in charge of the system are just brushing it or sweeping it under the carpet. The carpet itself has become like a garbage dump now, like that you have in the extremities of the national capital. The garbage has become so much that it's like a mountain, but yet we are not willing to address these issues. And because you're not willing to address these issues, you're giving a handle to the executive to needle you with this, to manipulate and to have its way. And at the end of the day, what happens? The casualty is judicial independence. The casualty is the consumer of justice. And the casualty is that you have these antiquated laws, the Contempt of Court Act, which we are talking about, which remain to be used, God knows against whom. And let's be very clear, the next person may not be as lucky as Mr. Bhushan to get away with 1 rupee.
Exactly. True. I think, sir, you've brought out a very important point, which is that, independence and accountability they go hand in hand. And unless we deal with one, dealing with the other is going to be very difficult. On that note, Arti, I would like to bring you in and ask you that, when it comes to, let's say, independence and accountability, we count a lot on, like people like Bhushan sir, who are vocal, even journalists, media persons, artists, etc. Who play a very important role. They are the ones who can lay out the criticism in a manner which is understandable by people, which people can grasp and understand. Do you think that, and one thing which I've noticed is that, at times, and because if you look at these contempt cases, you see that they take a lot of time in being decided or, reaching conclusion. Do you think the way we say in other cases, such as, for example, UAPA, it's often said that process is the punishment. Once you institute a UAPA case, the process of it is so long that, a person will suffer enough. So similarly, in cases of contempt, do you think process is the punishment itself of trying to shut somebody up? That, once you put a contempt case against that person, against, let's say, a journalist or somebody, who has to speak out, they would self-censor themselves immediately from that point. And then you can take years and years for that case to sort of conclude while effectively, shutting that person. So what do you think is the impact, or, how does it really play out?
Well, absolutely. The process is the punishment. I wouldn't compare contempt proceedings to UAPA proceedings.
No, of course.
Of course. But I mean, it is. It has significant cost and time implications. It has professional implications, whether you are from the legal fraternity or not. So to take the example of a lawyer within the legal fraternity speaking out, there is the potential of disbarment proceedings should it go south. There is the immediate pain of having to attend and defend yourself. These things languish in court indefinitely. And it also acts as an effective deterrent against those with the most amount of knowledge about the system against speaking out. A couple of years ago, there was a lawyer in Delhi, Reepak Kansal, who filed a petition before the Supreme Court alleging arbitrariness in the listing of matters before the court. Now, any advocate will attest to the fact that listing is one of the most opaque aspects of the functioning of a court. This petition was not only dismissed, some costs were imposed and contempt proceedings were threatened. The judge in question was Justice Arun Mishra. Now, I mean, he's not, this sort of discouragement of criticism of the court is not unique. And it's extremely problematic because it poses as a huge threat to the continuation of a successful career when it comes to people who want to voice their opinion or speak out. So this is, insofar as lawyers who come into the crosshairs of contempt law go. And it's equally true of people outside the law, because the law also creates this very piquant situation where, for instance, in Mr. Bhushan's case, the court took issue that it is a person from within the establishment, a lawyer of considerable standing, who is speaking and bringing this institution into disrepute. Whereas in Ms. Arundhati Roy's case, the court said that, look, you know nothing about the functioning of a court. You have no authority on the subject, so you shouldn't be speaking about it. So it's a bit of a damned if you do, damned if you don't situation, where really nobody should be commenting about the judiciary. And it also goes to then what form can the criticism be in? Does it have to be in the form of, measured and detailed and, often dry journal articles and academic prose? Or can it take the form of, engagement through entertainment? And unfortunately, I mean, the legal fraternity has not countenanced this. You forget contempt proceedings. When Jolly LLB came out, there was a petition filed before the Bombay High Court. The court took it upon itself to review the movie and had a committee appointed to order cuts to the movie, because apparently the legal fraternity can't handle being poked fun at. So yes, I mean, there is a general inability of the institution to take it on the chin when there is criticism, which is not necessarily in a palatable form, which is not necessarily in a dry and boring form. And, tied to this is the distinction that is made in contempt jurisprudence about criticizing judgments versus criticizing behind judgments. And, they said, oh, you can criticize the outcome in certain matters or the basis of the judgments, but don't speak about the motives behind, that may have prompted judges. But I mean, you must ask, why not? I mean, judges, like any other public authorities, may be prompted by motives, some good, and on some occasions, questionable motives. And these are not easily discernible. There aren't a handy trail of breadcrumbs that will lead you to these motives. Very often it is by inference. It is by looking at surrounding circumstances. And it goes to, the point that the question that you raised to Mr. Ghosh earlier, which is, how do you deploy truth as a defense in these sort of situations? How does anybody defend themselves in these proceedings when the truth is not, a handy set of documents that you can furnish? And more than that, even if you do have evidence, the court has discretion as to whether it can permit this evidence to be led or not, because the law says that only if it is bona fide and if it is in public interest can you even use the defense of truth. Yes, I mean, I know the question you'd originally posed to me is, how does it affect people who wish to speak up? It does have a chilling effect, like a lot of other laws that restrict freedom of speech. The process is painful, it's expensive, and it acts as a deterrent. But I mean, it's not unique to contempt law. It's the case with even defamation. It's the case with criminal defamation. It's the case with a host of provisions under the Indian Penal Code that can be invoked against various forms of speech, regardless of whether the subject matter of the speech is in fact in a position of far greater power and authority than the speaker. Our laws are sadly not power agnostic. They are power agnostic. It doesn't recognize relative positions of power, which it really ought to. And the people who bear the brunt of it are those who really do wish to speak truth to power. So,
thank you, Arti. I would, I mean, there are many things that we can discuss on this topic, but I think now we're running out of time a little bit. So, I mean, obviously, I'll come to both of you and ask you for your last comments and, what do you think is the way forward? But Sanjoy sir, one last question that I think, I really want to ask you, which is that, let's say that even if we could think of, or we could reframe the, the act and think of and limit it to actual scandalizing or lowering the authority, terms which are, let's say, very vague. If you could come up with a formulation and restrict it to even, like it is in sedition, like, it's the application is to imminent threat or public disorder, etc. So even if, let's say, we can think of a formulation like that for contempt, do you think, a standard can be derived at, considering, the whole concept is so vague? Basically what I'm trying to ask you is that do you think there is any possibility of reform when it comes to these aspects of scandalizing the court, lowering the authority of the court? Or do you think, the way forward would be to completely sort of remove or abolish this aspect of criminal contempt from our law?
Well, sadly, my personal view, of course, I'm open to education. My view is that there can't be any kind of gradation, because the concept is essentially so vague. Unless, when you talk about authority, overthrowing the authority or whatever, scandalizing or whatever, see, the general law of the land deals with insurrection, deals with violence, deals with defamation. So all the aspects are already dealt with under law. It's not that it's not there.
Right.
But rightly or wrongly, and has been very nicely captured by your report, the Constitution, while being drafted, they've inbuilt the concept of contempt. Okay. Even without a legislation, the inherent power of the court to take action on contempt is there. In fact, I was a standing counsel of the Delhi High Court, and in a contempt, we just found that a creative defense was used by one of the persons convicted, all the way from the Supreme Court. He said that now you have not framed rules as to who will arrest me and how I'll be arrested, how the warrant of arrest after the conviction will be used. So many courts have not even formed those rules. So, it's the vanishing point of jurisprudence. Also, courts also don't know how to deal with it. They always hope that contempt hoga, the person will say, I'm sorry, and will comply, or will file an affidavit of apology. So very rarely also, let's be very clear, very rarely actually people go to jail or even are fined the way they're fined. Sometimes courts are also very creative by giving fines of community service, or, plant some trees or do this or do that. But to answer your question straight away, I don't think there is any possibility of, unless you say it is, shaking the complete foundation of the court, in as much as the people do not anymore accept the lawful authority of the court. That high standard, the standard of a rebellion, I don't see how, the rest of it is all subjective. To what extent can you say that the authority is affected? So again, and let's again look back at stable democracies like in the United States and the United Kingdom. They have actually survived without this power being with them.
Right.
So, if they can survive, surely we can. And let's be very clear. For example, in the US, their First Amendment, read with their constitution, the right to free speech is much more than ours. So we already have inbuilt a restriction on our free speech. If the US Supreme Court and the US system can survive with that high threshold of free speech, then, we are not in any danger if you do away with criminal contempt completely.
Absolutely. Arti, your last thoughts, and I'll ask the same question to you. Do you think there is a possibility of reform in these aspects of scandalizing, lowering the authority? Or do you feel that we need to, like Sanjoy sir was saying, that we need to do away with this, these vague concepts that are there in the law?
I have to say, I agree with Mr. Ghosh. I don't think that there is a truncated definition that can stand. Courts of law are not like a religion that requires faith in order for people to turn to it. We turn to courts because that is the only legitimate recourse that we have for redressal. It isn't for any greater or more lofty reasons. And I think it's perfectly possible for a litigant to turn to a court despite not having any faith. And I don't think that can be a precondition to turning to court, despite what the Supreme Court told Mr. Mandar when he filed a petition. And he was confronted by a speech where he apparently suggested he'd lost faith in the court. And the Supreme Court said that this must be inquired into, had the Delhi police file an affidavit with a transcript of his speech. I mean, that entire episode was entirely regrettable because the truth is that regardless of what your opinion of the court is, as a citizen, you have a right to seek recourse to it. And the court is nobody to interrogate what your beliefs of the court are. And so the entire philosophical foundation to criminal contempt, which is that the citizens must have faith, just doesn't hold. And I don't think that there is in a democracy, there is any place for a law such as that of criminal contempt.
Thank you, Arti, and thank you, Sanjay sir. I think one conclusion we have definitely reached at here is that we shouldn't use law and more specifically criminal law to demand faith from us, from the system, and especially from the judiciary. Thank you so much. I'd like to ask Mehwish to sort of wrap this up and to give us a vote of thanks. Mehwish.
Thank you. On behalf of Part 3, I would like to extend a heartfelt gratitude to all our panelists today. Mr. Prashant Bhushan, sir had to leave early, Mrs. Sanjoy Ghose and Ms. Arti Raghavan. Thank you to each one of you for taking out time to be part of our webinar and the launch of our report, which is first in the Samvidhan series. Needless to say, but also again pertinent to mention that extremely relevant observations made today and that have set forth a context for a more critical and a nuanced conversation and engagement with the law of contempt in India. All of you have really helped us unpack the word of law, and that is what we hope to achieve through the Samvidhan series. We are hopeful that today's dialogue and also our report finds resonance with lawyers, academicians, activists, and all those who wish to engage with the law. A kind word of acknowledgement for all those who contributed to our report, the author, the researchers, the designer, and everyone else. Thank you so much for joining us today. Also, thank you, Mangla, Ratna, and Abhilasha for this wonderful moderation. Thank you to LiveLaw, our host. Thank you for hosting this webinar. Our report is accessible on our website, part3.org. We eagerly await for your suggestions and feedbacks. We love to hear from every one of you. So thank you everyone for joining us today. Thank you.
Thank you all. Thank you so much.
Thank you all. It was a pleasure. Thanks.